Gilgo Beach murder case. A New York judge has ruled that newly obtained DNA evidence will be allowed at trial against Rex Heuermann, the man accused of killing 7 women whose remains were found on Long Island. Prosecutors say advanced whole genome sequencing ties Heuermann to 6 of the victims, while the defense had argued the technology was too new to be admissible in court. Joining us now to break everything down, Rich Schoenstein, trial attorney. Rich, good to have you with us. How are you?
Very well. Good morning, Chris.
Good. So the defense argued that this technique was untested in New York courts. Now that it's admissible, how might they pivot their strategy at trial?
Well, I think the strategy is the same, except they're going to make their argument to the jury instead of the judge. The judge is merely acting as a gatekeeper here. Can the evidence come in? But the defense can still argue in front of the jury that it's unreliable. They can bring in their own expert witnesses to contradict the theory or the testing, and they can still challenge all of the aspects of this DNA testing in front of the jury.
So let me ask you about this kind of argument that the technology is too new. I mean, I'm sure the same was said about DNA when they first brought that in years ago. But what are your thoughts on that? Because you look at the percentages and you look at the likelihood of the connection being made, and you just say to yourself, well, I mean, this kind of spells it all out.
Right. I mean, every technology is new the first time it's used in court, and every kind of scientific evidence has been used in court for a first time. So the judge, again, is acting as a gatekeeper here. That doesn't put me off if the judge is otherwise satisfied that the kind of scientific testing might be reliable. And once again, the defense still gets to argue in front of a jury that this is too new and undeveloped and you shouldn't believe it.
Yeah, and it also sets them up for an appeal should he be convicted. We'll talk about that in a moment. But first, though, judge still has to rule on whether to split this into multiple trials. So what are some of the pros and cons on that decision for both sides?
Right. So the prosecution wants to keep this at one trial because part of their theory is that these separate murders, 7 of them, are part of the same pattern, part of the same plan, all done by the same defendant. And the fact that there are more than one of them is great proof, great evidence for the prosecution. The defense wants to split that up so they don't have this tide of different murders. But I'll tell you the problem with that theory, Chris, is if the defense prevails, in theory, they could have 7 different trials, and now they have to win every time in front of a different jury, and the prosecution gets to do it over and over and over again. So I'm not sure. I understand why the defense is taking this position, but I think there's also something to be said for having it consolidated.
And so let me ask you this. Let's say he is convicted and all these questions about the technology being new and whatnot. Does the fact that they keep hammering that point home, even though when you look at some of the items that we've shown on your screen here, that the likelihood that he is connected to these murders almost seems insurmountable. The fact that they keep hammering home the questions about the technology, is that the grounds for appeal? Is that the central point of a potential appeal?
Well, right now, that is the ground for appeal that is apparent. But generally in these cases, the defense amasses all sorts of different points of appeal over the course of pretrial and trial. So surely they would argue to an appellate court that this evidence shouldn't have been allowed and that it's prejudicial. And we have to see how the trial plays out to find out if it would be what we call harmless error. Because to your point, if the rest of the evidence is so overwhelming, the DNA evidence may not even tip the scale.
And let me just ask you this. Could this ruling set a precedent for other cases in New York down the line, especially cold cases where like only rootless hairs or limited DNA evidence exists?
It does set a precedent. It is the first New York decision allowing this form of DNA testing to be introduced at trial. That is, by definition, precedent for other courts, especially in New York, to go ahead and allow the same kind of evidence. I don't know if it will restore cold cases. It could, but going forward, it certainly is a precedent for putting in this type of evidence.
All right, Rich, good to have you with us as always. Really good to talk with you.
Great to see you.
All right, we'll talk soon. For all the latest information surrounding the Gilgo Beach murders, you can head over to CBSNewYork.com. Just about 8:22 for you right now.